All right, everybody, one more minute. We're going to get started. All righty, it is 10 a.m. So we are going to start learning about the NABOR versus FAR contracts today. I'm really excited for this presentation. It's one of my favorite. We're going to talk about the contracts, the differences, the similarities. And just as a reminder, for those of you that have been on the webinars before, you can feel free to put your questions in the chat or unmute yourself and ask a question. I'll monitor both. Let's keep the war stories to a minimum, although they can be useful tools. This is going to take about 45 minutes to an hour, depending on questions. And I'm going to get started right away. So we are recording this, so you'll be able to watch it on my YouTube channel later. And of course, because I'm an attorney, we're going to get started with a disclaimer. This does not present and create an attorney-client relationship. And if you have specific questions with your customers, you and them can always call me after the presentation, and we will go through your scenario and help you out. A little bit about my law firm. I was founded in 2007, and we focus on real estate and business law. We have a litigation department, and we are throughout Southwest Florida. Just a little bit about me. I've been an attorney now since 2003, which puts me at 19 years. It's a little scary. And I focus my practice on real estate and business transactions. I'm a member of Legal Resources at NABOR and the Real Property, Probate, and Trust Law section of the BAR's Real Estate Industry Liaison Committee. Anybody that can say that 3 times fast, you get a gold star. I am a recovering politician, so you have to excuse any jokes. Let's talk about what we're going to do today. We're going to go and compare the Florida Bar, Florida Realtor contract with the Naples Area Board of Realtors contract. We'll talk about the pros and cons of each contract. We're going to use the main contract as the basis of our discussion, and we'll talk about the as is where it's appropriate. I made a bunch of slides, obviously, that you're going to see on your screen today. They're going to compare the differences. I will also point out similarities as we go. Before we dive into the contract itself, one thing I want you to recognize is that these contracts are your tools of the trade, as we like to say. They're tools for you to use to get the deal closed, so you can get a commission, so you can get a closing, so your customer can get a new house, so your seller can sell and move on. And they both have positive attributes. They both have some concerns. And the real issue for you as a realtor is, who do you represent? What are their needs? And which contract is the best for you to pick based on your customers' needs? And that's can be a point of negotiation, can be the form, not just the price or the inspections or the financing, when you're negotiating with the other side. So just be mindful of that. Think about things like the FAR financing is somewhat cumbersome, but the NABOR inspections are very exacting. So we'll go through all that. Let's start from the top of the contracts and go from there. You don't need to have the contracts in front of you. If you do, and you want to talk and ask me specific questions about lines, that's fine. Our line numbers may not match up, but we will figure it out, and I will answer any questions you have as we go through this. So let's start right at the top of the contracts, and that is with the property description form. pull. There it is. So property description, things that the contracts both start off by telling you that you're going to convey the real property, and then you're going to convey the additional personal property with real property, and what conveys and what doesn't. Well, right off the bat, the first thing that I always hear about from realtors is, I didn't know the washer and dryer didn't convey when they're used to the NABOR form and they use the FAR/BAR form, and then they're buying a washer and a dryer for their customer. So be very mindful of the list on the contract that says what conveys. The FAR/BAR says the built-in appliances and built-in furnishings convey. The NABOR contract provides a comprehensive list of items that convey, and it defines all of it as property. Note on the NABOR contract that landscaping is included. The smart home features convey specifically in the NABOR contract. And in the FAR/BAR contract, this is a new addition, but the smart home features convey there as well. One thing you'll notice, the FAR/BAR asks for the property identification number, whereas the NABOR does not require the property identification number, but it does ask you to identify by identification number or letter the parking spaces, the garages, the boat docks, the storage lockers, the cabanas that are associated with your specific property. One thing I'll mention here is the FAR/BAR has an addendum that says for associations, and you would be able to put on that where you can add the parking spaces and other things. Notice that it's clear under the FAR/BAR that if it's screwed or glued, it stays. The NABOR provides an exclusive list. And so if it's not listed, it may not convey. You have to be very cautious about those and be specific. Both contracts contain blanks for items that are specifically conveying personal property items and things that are excluded. Don't be shy about creating an inventory list. Let's see. Tracy's asking how is built defined? Built-in defined. Built-in means if it's screwed or glued, Tracy. And you'll hear me say that in a number of different presentations. If it's screwed or glued, it stays. It's part of the real property. Josephine, I will get to the escrow dispute parts in a little while. Okay, let's talk about the offer and acceptance. This is very important when you're calculating your days for inspections. The FAR/BAR specifically says that the effective date is the last date signed and delivered, whereas the NABOR says that the effective date is the last date set forth on the contract next to either party's signature. So you get into how many days do I have for inspections? You could conceivably be in a situation under the FAR/BAR contract, or sorry, under the NABOR contract, where it was late at night, the seller signed late and put the date of today, but the buyer didn't get the contract until tomorrow. Well, the buyer has been under contract, and day one is the next day after the last person signed the contract. So you want to make sure that you get your contract delivered under both contracts as quickly as possible. Under FAR/BAR, it's not effective until it's delivered to the other side. So if you're going back and forth with your counter offers, you want to make sure that final fully accepted and executed contract is delivered to the other side. In the FAR/BAR contract, they define the closing as happening when all the funds and documents are received by the closing agent on the closing date at the time decided by the closing agent. Whereas closing is not defined in the NABOR contract, it just has to be on the closing date in the county where the property is located. Of course, I love NABOR, but I think that having a defined closing procedure is a good option to have, because it's questionable. When do the keys pass? That's always the question. When do the keys pass? Well, the keys are supposed to, in both contracts, be delivered into the closer, to the closing agent at closing, and then they're passed after closing to the buyer at the same time that we distribute the funds to the seller. So it gets a little, I get the question from the listing agents, my seller won't release keys until he gets his money. Well, that's not what the contract, either contract says. Both say deliver the keys and access devices into the closing agent for closing. One other thing about the closing date, there are very few instances where the closing date can be extended. If you meet the CFPB compliance requirements under either contract, you get a 10-day extension for financing in the NABOR contract. And this is a new change to the FARBAR contract. Instead of 10 days, you now only get 7 under FARBAR version 6, which is the newest version that's in your forms folder. Mike has a question on the previous slide, so let me just stop there for a second and say, Mike, the fridge that just rolled into a hole would not convey under the FARBAR, whereas something that was built into the wall would convey. That's exactly correct. Okay, so any questions about offer and acceptance or the real property versus personal property? Yes, Barrett, you can close. I will close in Lee County. I have offices in both. Okay, assignability. Let's talk about that. So assignability is kind of a big deal for the buyer, because if you're going to put the property into a trust, or if you're putting the property into an LLC, you're going to want to make sure that you can do that, even if the LLC or the trust or the land trust, whatever vehicle you're going to use, is not ready in time for closing. So the FARBAR contract has a checkbox for assignability, and it has 3 choices. The buyer could assign the contract and be released. The buyer could assign the contract and not be released, or the buyer could not be allowed to assign the contract. Now, I will say this, in the new FARBAR contract, this is the default. If you miss this box, which is in section 7, you will have a non-assignable contract. So if you've got a buyer who's going to be putting the property in an LLC or a trust, or buying for a child, to have that, or some other reason to assign the contract, a flip, maybe they're flipping the contract, then you want to make sure you check the appropriate box in the FARBAR, or you're not going to be able to do that. Contrast that with the NABOR form, which allows free assignability up to 15 days before closing. And actually, NABOR provides an assignment form, whereas FARBAR, you're going to need a formal assignment prepared by an attorney. Okay. So the next thing I want to talk to you about is the methods of payment. So if you're under a cash contract, they're very similar contracts. FARBAR has just amended their contract. All their cash deal says is, this is a cash transaction with no finance contingency. That's an error on my slide. Should say no. There's no CFPB window for compliance. You must hit the closing date. That's the same under the NABOR contract, where you check the cash box. It says you can still get financing, but again, there's no CFPB window, and you must hit the closing date. Now, I will say under FARBAR on a cash deal, you can get financing, and there is a provision in FARBAR that would allow access for the appraiser and the surveyor. I believe it's section U, but the standard U, but there is no provisions to protect your buyers who are getting financing in either contract. So be very, very careful of that. Okay. So when you're getting financing, they're vastly different contracts, very different in the way they treat financing. And I'm going to go through this here in some detail. The first thing in the FAR-BAR contract, the default is a 30-day loan approval period. And they just changed this in FAR-BAR. The appraisal contingency is now a part of loan approval. There is no separate appraisal contingency in the FAR-BAR contract. And the buyer must terminate the contract in writing before the loan approval period ends. Loan approval period is a defined term in the contract. It's the 30-day or 45-day period where the buyer's got to exercise a diligent effort, pay for the appraisal, pay the lock fee if it's required. And if the buyer can't close under FAR-BAR, they're going to lose their deposit. NABOR is very different. Buyers, the default is 45 days to get financing. If the buyer does not affirmatively waive the contingency in writing prior to the seller making an election to terminate after the finance contingency period is over, then the buyer will have the right to terminate, provided that they provide an adverse credit action letter or proof of good faith and no approval or denial. So saying that again, from the buyer's side, they have so many days to secure financing. When the period is over, when the finance contingency period is over, the buyer can terminate and get their deposit back under NABOR, provided that there's been an adverse credit action, that means they've been denied, or they have exercised a good faith in applying for the mortgage, but have neither received an approval or a denial. If the buyer does not want to waive their finance contingency, does not want to terminate the contract and wants to lock the deal in, even if the buyer is not approved yet, the buyer can waive the contingency in writing, and then the seller would not be able to terminate. Because looking at this from the seller side under NABOR, once that approval period is over, it's an opportunity for the seller to better deal the buyer by terminating, giving the deposit back, and in a rising market, getting a better deal. Any questions about financing so far? Okay, I don't see any. So let's talk about a very difficult case that's come up that has caused the FAR-BAR committee to revise the contract into the current version. Version 6 is a direct result of the Lafont case, which basically the court bent over backwards to give the deposit to the seller, saying that the buyer did not apply for the loan that they said they were going to apply for. And because they didn't apply for the correct loan, there was no loan approval to be had. And so the buyer was in breach and the deposit went to the seller. What this case really means for you as a realtor, if you fill out your contract with your financing, in both contracts you're going to pick, it could be conventional, it could be FHA, it could be VA, it could be a different form, and an ag loan. You check the box in your finance contingency for the type of loan that's going to be provided. You put the amount of the loan on page 1, you put the interest rate, which, by the way, another difference in the contracts in the FAR-BAR, it defaults to the prevailing market rate. If you don't put an interest rate in the blank in the finance contingency, in NABOR, it does not have a default for the interest rate. And so you must put something in that blank, or your buyer is going to be subject to whatever rate the bank gives them. The final lesson on this slide is amend the contract if you amend the financing. If you start with a conventional loan, but then you realize that your client is a veteran and they can get a better deal from the VA and you switch to a VA loan, amend the contract change the checkbox in the finance contingency for either contract so that you don't run into the Lafont case and have a situation where you've applied for the wrong loan. Okay, questions on that, on financing? Okay, Darlene is asking, what if the roof blows away after a hurricane? Darlene, that's a great question. We're going to get to that as soon as I talk about force majeure in a few slides. Okay, seeing no questions about financing, I'm going to move on to the differences, the way they treat homeowner associations and condominium associations. So under the FAR-BAR contract, when you're dealing with a home in an HOA or a condo, you have to pick the correct addenda. The transfer issues, the closing issues related to HOAs and condominiums are not in the standard or as is FAR-BAR contracts. Must use the correct addenda. That talks about the approval and the right of first refusal. They talk about the association fees. They disclose them on the addendum, and special assessments are negotiated as a part of the association addenda. And the default under the FAR-BAR contract is that the seller pays all association dues that are due before closing. Contrast that with the NABOR contract, where the language is in the contract template. There is no condo or HOA addenda for the NABOR contract. And the seller pays all assessments that are due before the effective date. So if you are in the middle of an Irma roof replacement and the insurance it hasn't paid out yet, and you're trying to figure out whether there's going to be a special assessment, if it's under the NABOR contract and it's not in place prior to signing the contract, the buyer will pay it. If there is a pending assessment, which if you look in section 6 of the NABOR contract, sentence 2 talks about pending assessments that are not yet effective, then the seller must disclose what he knows about the assessments. And if they're not properly noticed, then the buyer pays up to, I said this is backwards, this is wrong. The buyer pays 1% and the seller pays the difference. And the buyer is required to investigate and understand the community requirements in the NABOR contract. So there's when you get there and the buyer is going through and looking at the association and they visit the property, and then they realize they don't like the association, or they don't like the golf membership, or whatever it is that they're upset about. If they've already signed off on the condominium documents or signed the HOA disclosure, it's on the buyer. They can't get out of the contract. And that's specifically stated in the NABOR contract. It's the same in the FAR-BAR contract, but it's not specifically stated. And again, the required statutory disclosures are in the main contract, whereas in FAR-BAR, the statutory disclosures are in the addenda. So Lisa is asking, which contract is better for a condo owner regarding the payments of the assessments? I don't know that either one is better. I don't like in the NABOR contract trying to figure out what pending means, but both contracts require the seller and the to know what's going. They assume the seller knows what's going on in the association, and they have provisions in the rider for FAR-BAR to negotiate the special assessments. And of course, if you have a pending special assessment and you want to negotiate it, you can do so in the NABOR contract as well. I think a direct answer to your question is, Lisa, that FAR-BAR probably is a little bit better, but NABOR has really good other provisions like inspections and financing for buyers. Do buyers need to acknowledge receipt of the condo docs? FAR-BAR has two choices, Isabel. for acknowledgement of the condo docs, you can check the box right in the contract that says they've already been received, or you can have them delivered prior to closing. And of course, you run the risk, you still get the 3-day right of rescission. Barrett is asking, under the HOA, since there's no 3-day review, should you write this in? Barrett, whether you should write in, you shouldn't write anything into the contract, first of all, unless you have it blessed by an attorney. If you want to have an HOA document review, NABOR, it provides an HOA document review addendum, and it gives the buyer 3 days to review HOA docs from when they're delivered by the seller. Other questions about condo and HOAs? Okay. Oh, Barrett, so the FAR bar does not have an addendum for allowing the write-in, allowing the HOA docs to be reviewed. It's just the HOA disclosure. You would need a special addendum drafted by an attorney if you have a FAR bar contract and the buyer wants to review HOA docs. And the 3 days start the day after the document, the condo documents for the HOA disclosure is delivered, and it excludes weekends and federal holidays. Jim, there is a condo disclosure in the NABOR contract. It is, I'll tell you exactly so you can look it up. It is standard H and standard I. Brittany is asking, what if condo docs are already in the MLS with the listing? You still, Brittany, need, oh, this is a great question. Brittany, you still need to make sure that the buyer sees eyeballs on the documents, electronically or in paper. Delivery to the agent does not count. That's why it's so important to use the condo doc receipt form that NABOR provides, and FAR bar does not provide it. And I know you're not supposed to mix the forms, but if you had to use the NABOR condo doc receipt on a FAR bar contract, you could do that. They don't reference each other. But you need to provide the documents directly to the buyer. They can't just be in the MLS. Okay. Oops. Yes, you want to make sure it's advisable, Barrett. The buyer is asking to be clear in FAR bar. Should you have the HOA amenities engulfing reviewed by the buyer up front? Yes, you should. Okay, let's talk about title insurance. My favorite part, the title insurance. So under the FAR bar contract, you would check a box for who picks the title agent and pays for the owner's title policy. The lien search under FAR bar follows the title insurance. This costs $115 to $120. It's a small expense, but it's a very important document, and it's chosen by the person who pays for title under FAR bar. And now one of the big differences between FAR bar and NABOR that can extend your closing and be a real problem is when you get the title commitment back. And I'll brag about myself in my office for a minute. We order title right away so that we don't have a problem with extensions usually because of title defects, because we get them cleared up before closing. If for some reason you didn't order title under the FAR bar until 5 or 15 days before closing, you may have an extension for closing if a title defect appears, and the contract provides for an extension for a cure period and an additional cure period. You could literally have an extension for 150 days. So you've got to make sure that you work with a title company that orders their title documents immediately to avoid that problem. Under NABOR, the buyer picks the title agent regardless of who pays for the title. It specifically says that in Lee and Charlotte County, the seller pays, and the buyer pays in Collier. Those are negotiable points, just like the FAR bar. It's just you would have to change the default language in the contract. So if you've got a situation where you're going to swap doc stamps for title, which some people will do because the seller wants to control the closing and the doc stamps cost more than the title, so it lowers the seller's costs and gives them control. You can do that. It just has to be written into the other terms and conditions of the NABOR contract, whereas under FAR bar, you just check the appropriate box. One thing under NABOR, the title commitment is due to the seller 10 days after the effective date. So you, under NABOR, if you know you're going to have title issues, you may want to use the NABOR form just to get the title done right away. Isabel is asking, if title company did not provide the title insurance within 5 days, what happens? Can the buyer cancel the contract? It's not within 5 days, Isabel. It's 5 days prior to closing. And if the title is not provided within the time period in the contract, the buyer may be in a situation where they're going to take title as is. There may be title defects, there may be problems on title, but the buyer lost their right to object to the title defects when they didn't timely provide the commitment. So that's another thing to look out for. Make sure that your favorite title company, which hopefully is me, gets the title commitment ordered timely and gets it out to the other side timely. Okay. Well, here, before I get to inspections, any questions about title? Okay. Inspections. So very, very different ways to handle inspections under the FAR bar main contract and the NABOR main contract. Of course, the as-is contracts, both are essentially a free look. Any reason or no reason to terminate under as is. But going through the FAR bar, you get 3 inspections, general, WDO, and a permit. And one thing I could add to this, there is now an addendum for mold under FAR bar. That's a new addendum. So if you want to get a mold inspection, you can do that. Just have to use the new addendum, and lead as well. FAR bar requires the seller to make repairs up to the 1.5% typically listed. They call it the repair limit, the general repair limit, the WDO repair limit, and the permit limit. So if you have inspection items that come up that do not exceed the repair limits, which default is 1.5%, then the seller will spend the money, whether they want to or not, to get those repairs done. If the repairs exceed the repair limit, then the parties give notice to each other and they discuss it. And if they don't get it sorted out, then neither party can terminate. It's a little cumbersome, inspections under FAR bar, and it's very rare that I will pass a judgment on a particular contract, but I happen to like the NABOR inspection process better. You get 6 inspections under NABOR: systems and equipment, radon, lead-based paint, WDO, mold, and open permits. It's obviously a much more comprehensive look at the property. In the default, you don't need any addenda. The seller is limited to the fair market value to put items in working condition. So if the buyer chooses remedial action or a credit under the NABOR contract, then they give their inspection election to the seller. They say, seller, I want a credit of so many dollars, and here's why. The remedial action would cost the same amount, but we just would rather have the credit. It's very limiting, and the NABOR contract is designed to keep the deal together. I think much better than the FAR bar in terms of inspections. If the seller does, however, choose not to make any repairs based on the buyer's election, then the buyer can terminate and walk away. But I think the way that the NABOR is put together, it's a little bit more fair than FAR-BAR. Although I do have some realtors who like the specificity of the FAR-BAR contract, you know, and continuing on here about the specificity under FAR-BAR, you know, things like torn screen, fogged windows, missing roof tiles or shingles are repaired, whereas under NABOR, they're not. They're cosmetic, you know, and then the FAR-BAR has a procedure for dealing with disputed inspection items by using dueling experts. My inspector and your inspector get together and pick a third inspector who decides whether something is actually defective. Whereas NABOR, if there are discrepancies in the inspection report, then the parties have to figure it out and negotiate, and ultimately the seller can accept, reject, or counter the buyer's election. One thing about open permits, very important, open permits for those of you in Collier County, you know that Collier County Board of Commissioners wants to make sure that all those permits get closed out. So you've got to provide the permit brochure under NABOR. And under NABOR, you can do a permit inspection up until 5 days prior to closing. And whereas, and even though there's no extension, if you do find open permits, and under FAR-BAR, could be up to a 10-day extension for final inspections, but you've got to find your open permits within the inspection period. So that's a little back and forth difference between the two of them with regard to open permits. Questions about inspections? Okay, we'll talk a little more detail here because it is so vastly different. The buyer under FAR-BAR will notify the seller within the inspection period of the defective items. This is for permits. I'm sorry, make sure you understand this is for permits. The seller has to provide documentation that they have regarding the permits. You go through an inspection process. And again, if the costs exceed the permit limit, the seller fixes all or the buyer gets a credit. Under NABOR, the buyer or the designated representative conducts a permit search, and you have up until 5 days prior to closing to get that done. Now, the seller does get 10 days to respond, but closing is not extended specifically for permit issues under NABOR. Questions about inspections or permitting? Okay. Force majeure. So who asked that question earlier? Darlene, what if a roof blows away after a hurricane? Well, Darlene, if a roof blows away after a hurricane, you have to deal with casualties under NABOR. And the seller bears the risk of a casualty. They would put the house back in order unless the buyer cannot get insurance, which of course a roof blowing off would negate insurance. And there is no force majeure clause under NABOR. If you have a hurricane come through, then you wait when you're in the box for the hurricane, you wait until the hurricane passes, and then you can extend up to 30 days for closing if there is a casualty. If the property is uninsurable, the buyer can terminate. Under FAR-BAR, there is a force majeure clause. If you cannot overcome the force majeure event, which includes pandemics, by the way, in the new version, then you, by use of reasonable diligence, then you can extend the closing up to 7 days past when the force majeure event occurs, with a maximum extension of 30 days. And the new, like I said, the new contract specifically includes pandemics. Darlene is asking, how do you protect your buyer if the permits are still open at the time of closing of the NABOR contract? That's a great question, Darlene. Under the NABOR contract, if permits are still open at the time of closing, you escrow 200% of the cost to close the permits. And I will say this, and the new NABOR contract that comes out next year, there will be a better system for dealing with that and determining how much to actually put into escrow. And I will leave you in suspense. So you'll be able to come into a future class and I will explain that once the new contract is out. So probably one of the most important parts of or differences between the two contracts is the time being of the essence for the every deadline under FARBAR. You can't miss your deposits. You can't miss your inspections. You definitely can't miss your closing or your finance dates. Under NABOR, time is only of the essence for closing. But I will say this, there is a case, Nakachui Court versus Pickett. In this case, the court does say that deposits are so important and integral to the contract that you should not miss that deadline. Under FARBAR, since time is of the essence, if you miss your deadline, the contract terminates automatically and you can relist the property, resell it, and go on to fight the deposit fight with your old buyer. Unless of course your old buyer thinks that they were correct and they file a lis pendens on the property, then you're going to be stuck. And a lis pendens must be filed with a lawsuit. So your buyer can't just run right out and put a lis pendens on the property. They have to file a suit, get a case number. The case number has to go on the lis pendens form that's filed with the clerk of courts. Under NABOR, you would have a notice of default and opportunity to cure for non-closing deadlines. The big one, of course, under NABOR is missing that second deposit or even the first deposit if you're having wire issues. And the way you do it is the seller then would send a breach letter, buyer, you're in breach. You have 1 business day to cure your breach, or 2 business days, or whatever it is that you agree is reasonable. And then the buyer has an opportunity to cure for non-closing deadlines. Let's see what we've got for questions. Okay, Josephine is asking, under the FARBAR, can the buyer assume the seller's insurance in Florida? What happens if buyer claims they cannot get insurance? Josephine, under the FARBAR or the NABOR contract, you can assume the insurance. That's not contractual. And then what happens if the buyer claims they cannot get insurance? Well, the buyer has to use reasonable efforts and diligence in both contracts. And if they don't do that, then they've got a problem. If they do that and they can't get insurance, I will have to check the contract and email you separately about whether they can terminate or not. I don't know off the top of my head the answer to that question. Darlene asks, what if missing the deadline isn't the buyer's fault? Easter Monday is a holiday in Canada, for example, so you can't transfer earnest money on time. Darlene, if the buyer can't transfer money on time under the FARBAR contract, they have a problem. Time is of the essence. Under NABOR, they would have an opportunity to cure. But remember, if a deadline falls on a weekend or federal, or I should say legal holiday, then you extend to the next business day. That, of course, does not, in your question, include Canadian Easter on Monday. But in the United States, when Easter is observed on Monday, I think you at least would have the argument that you should get another day. I think the better answer to the question, Darlene, is let's plan for that and not have the deposit due on a day when the bank in Canada cannot operate. So we would need to look at those issues and plan ahead a little bit. Okay, Josephine is also asking, under FARBAR, what are the time contains where the buyer needs to accept title survey? Can the buyer accept survey even if accepted from a previous owner? Under FARBAR, Josephine, I'll have to look and see exactly what the time frames are for the survey acceptance. I know that it's in here. I just don't have it memorized. I believe that the seller has 5 days after receipt of the survey, but I had to double check that, and I'll email you separately. Okay, so another big one, a default and dispute resolutions. Under the FARBAR contract, all deposits go to the seller if the buyer defaults, regardless of whether they were made or not. So if you have a default under the contract for whatever reason, in between the time that the first and second deposits are due, the buyer still could be on the hook for that second deposit if they breach the contract. Under both contracts, the seller has very few outs. Under NABOR, if the financing doesn't come through, the seller can terminate. And under NABOR, if the buyer makes an inspection election that the seller doesn't like, the seller can terminate. But if title is otherwise marketable under both contracts, the seller's going to closing. FARBAR provides a dispute resolution process. It's 10 days to resolve the dispute, and it's mandatory mediation if the parties don't settle. Mandatory mediation. You can't sue each other until you go to mediation first. And then under both contracts, the prevailing party gets their attorney's fees paid, which is an incentive, in my opinion, to sue. So we have to be very careful there. I would say another rare case where I'll make a judgment, the NABOR contract with the deposits made, I think, is a little bit more fair. If the buyer terminates in between the first and the second deposit, they should lose their first deposit. But I question whether the second deposit, if it wasn't due, should be paid. That's just an opinion. Okay. Let's see here. Any questions about the differences? Those are all the major differences between the two contracts. I promise you it would take 45 minutes to an hour. We have a few minutes for questions. You can unmute yourself or you can type them into the chat. Any questions? I know someone's out there. Lisa?
Oh, I have a question. Now in regard to, so people, we don't want to see people lose their earnest money deposits. I mean, I find that really disturbing if I was to represent somebody and lose that, because I really feel sometimes buyers, and especially because people come from other markets, they really don't understand the contracts.
They really do not understand.
And I really feel sometimes as agents, we don't understand the contracts. So I think it's imperative. Is there a way that we can have some kind of like a checklist? We don't have a checklist because I've worked in other companies where we had these very stringent checklists to stay on task.
Actually, Lisa, NABOR provides a checklist, a timeline checklist. It's one of the forms.
Mm-hmm.
So if you spend a lot of time in the NABOR world, I would use that NABOR timeline checklist that's provided so that you don't miss your deadlines. And understanding that time is of the essence for closing under NABOR and for all deadlines under FARBAR is something that the client needs to understand, because you're right. If you're coming from a New York or a Chicago, where they use attorneys for closing and they negotiate everything and all that stuff, you are going to surprise the heck out of your customer when you tell them, hey, you missed your deadline under FARBAR, you're going to lose your deposits. And it's deposits, not the first one. So that's a big deal.
And then also to conclude, just one thing, it really comes down to the integrity of a buyer and seller if they want to move forward with this contract. I mean, are you seeing that often is the case in some of the cases that you do? Or do people just say, oh, you're in default, I'm done? I mean,
it depends on the party. I think
okay.
I'm not going to pass judgment on any customers, but it depends on the party. And you're right. Some people will just be, you're in default, I want the deposit. Other people are willing to negotiate, and they don't want to go through the lawsuit process. Because I'll say this, it's not like you default and you get then the other side gets the deposit. If there's not an agreement, the title company is not going to release the deposit to the non-defaulting party immediately because they don't want to get sued by the defaulting party for something that the defaulting party says is not a default. So you will have to reach an agreement. And again, NABOR provides the deposit release and termination agreement form. And I strongly suggest that you use that form along with the buyer or seller notice of termination if you have a legitimate reason to terminate. It protects the realtor as well because there's a release of broker liability in that form as well.
Thank
We
you.
also have some questions in the chat. So before I get to that, Tracy, do you have a question? You're unmuted.
Yes,
Yes,
I have a
Tracy.
question. I was in a recent situation where the seller did have the right to keep the deposit, but they also didn't want to tie up their house and keep it off the market when, we're seeing changes in the market. So they decided to release the deposit instead of trying to sue for that. And I was representing both sides, which was really tough. And they at first were going to go for the deposit, but if they actually go to mediate or court, that would still mean I would have to take the house off the market, right? I mean, you can't.
Well, not necessarily. If there's no lien, if the buyer has not filed a list pendants, let me change your example for a minute. If the buyer, well, the phone rang and I lost my train of thought. I'm sorry.
That's okay.
If the buyer is not in, I say your question again, I'm sorry.
Okay, so I was in a situation where the seller definitely could have taken the buyer's deposit.
Oh yeah, if the buyer believes that they have a right to the property, they can file a lawsuit called a specific performance lawsuit. And along with that lawsuit, they could put a lien on the property called the list pendants. But if the buyer doesn't have a right to the property, a legitimate right to the property, and they file a list pendants, they're going to slander the title. And if the seller can sell the property before the litigation commences, there wouldn't be a lien on the property and the seller would be fully within their rights to sell. So in your question, you don't have to take the property off the market. As a matter of fact, once the contract is terminated by its own terms, there's an argument to be made that you could put it back active and resell it, and the buyer wouldn't have anything to say about that. Now, I will tell you, some brokers don't do that. So you need to check with your broker and understand the policy because they don't want to be sued for anything either. And it just depends on all the specific facts of the situation. Who breached, what, when, and how is a big deal. So
well, one thing to learn from my lesson is when you ask for loan approval, if they've made loan approval in 5 days, make sure it's the right loan, because
yes.
That's what happened. This buyer went for a commercial loan on a conventional loan, and they verified loan approval, but they didn't say what kind of loan. That
So
was
they
bad.
applied for a loan that wasn't listed in the contract.
They applied for a commercial loan on a residential property. And they
Oh,
verified
yeah,
to me
that would be a problem.
that,
If
and they
it
verified
wasn't identified in the contract as the correct loan, then the buyer was in breach the whole time.
Right. But so that's an important lesson for everybody to learn, because I talked to many realtors. They don't even check to see if loan approval is met in 5 days. I at least check.
You mean loan application?
Loan application, yes. Loan application is what I mean, in 5 days. I actually check, and here you got to be even more, you have to make sure they're applying for the right one that's on the contract.
Well, you have to make sure they're applying for the right one and in the correct time period. That's right.
Exactly. And a lot of people don't even, I've talked to a lot of realtors that don't even check it to see if they made loan application.
That's a good point. Yep.
Yeah, and I was shocked. I mean, I was shocked that even happened to me.
Sure. All right, Bud, you have a question?
Yeah, on the assignability on the bar, there are 3 choices. You don't assign it What about the first and the second? Which is the more advantage to the seller?
May assign but may not be released.
Okay. Thanks.
Okay, we have some questions in the chat. Let's see here. Is the effective date for the condo dates both parties sign or after 3-day right to review of the condo docs? Susan is asking, is the effective date for the effective date of the contract is the last date signed and delivered, Susan. It's not affected by the condo doc delivery. Now I'll say this, the HOA disclosure delivery, if it is delivered prior to execution of the contract, there is no 3-day under an HOA. For condos, there's automatically a 3-day no matter when the condo docs are delivered. So make sure you understand that. Darlene is asking, are the sellers out there hoping the buyer will default? I actually have not run into that, Darlene, where you get malicious sellers who want a default. Most sellers who spend their time listing with a realtor, getting pictures taken, doing everything to get it ready for sale, want a sale. Brittany is asking, the 10-1 arm pre-approval on the NABOR, will that just be specified on other option as an interest or preventing? I believe under NABOR, Brittany, you can choose on the regular form there, line 61, initial rate of interest not exceeding, and then you can put the interest rate that will be for the 10, and then of course it would adjust for the 1 later, and that would be after closing. So I would just check initial rate of interest on that if you've got an adjustable. Isabel is asking, cash buyer agreed to extend closing due to title problems. Can the buyer request clean title 5 days prior to closing based on the new timeline of the extension? If you've got an extension of the closing date, Isabel, and it's because of title, if it was extended, if the closing date was just naked extended, then the timelines are continue for title unaffected. If you extended the title clearance period under either contract, then you would have to go by whatever you wrote if you change the defaults in the contract. But it wouldn't be 5 days prior to closing. Now, maybe I'm not understanding your question. Josephine is asking, under the FAR cash deal, title search and survey is ready with an easement, and this has been presented to the buyer. Can the buyer wait just before closing to not take the property? Well, Josephine, if you've got a title search, the buyer has to make their survey objections. I believe under NABOR, it's 30 days. Under FAR, I think it's a little shorter. Title evidence is delivered. I believe it is, yeah, 5 days prior to closing. So you could go all the way up until closing, till 5 days prior to closing, Josephine, and then have title come out bad and have to do an extension. Okay, other questions? Feel free to unmute yourself or put them in the chat. We got 3 minutes left. Mike?
Hey, Sam, quick question. I've run into properties where the listing agent would say, oh, the buyer never made their deposit and just walked. So my question is, on a FAR contract, if there's a non-contingent contract, the buyer would be on the hook for both deposits?
That's
is
correct.
that correct?
It wouldn't even matter if there were other contingencies that were unfulfilled. If the buyer doesn't make their deposits, they're in breach of contract in both contracts. If the buyer misses, for example, the first deposit in the FAR contract, then technically the way the contract reads, he's in breach, the contract terminates, and the buyer owes both deposits to the seller.
Got it. Thank you.
Yep. All right, everybody. One last question. Yes, I will email the slides, Tracy. And Lisa's asking, do you see both these contracts adding a counteroffer addendum? No, Lisa, I don't think they're going to add a counteroffer addendum, at least to NABOR. And I'm not certain about FARBAR. And I don't think it's really necessary. I prefer that you scratch through the terms and initial next to it. That's allowed, that's easy to do with the new electronic signature formats that everybody's got available to them. So I would like to see people scratch an initial and date as opposed to use an addendum that can be very confusing. All righty, everyone, it is 11 o'clock. Thank you so much for your time. I will be emailing the slides and a YouTube channel link in a couple of hours, maybe in the morning. But if you have any questions, my contact information is on the screen. Please call or email or text or however you communicate whenever you need me. I love doing this stuff and I'm happy to help at any time. Oops. All righty. Take care, everybody.